happened in 1931, and so this case largely dealt with censorship of the press, what was okay to censor and what wasn't, and it also looked a lot at the 14th Amendment and the First Amendment, and it really talked about the different freedoms that people would have amongst the press. So before I start the article, something you guys should know is the 14th Amendment, Article 1, our quiz kind of addressed it, but essentially it's everything in the First Amendment, but it applies to the states now. The reason this was important is this happened purely in Minnesota and not on the national level, so it's more important. So kind of setting up the case, it starts with two men, Jay Neer and Howard Guilford. Neer was known for being kind of a bigot and a racist, and Guilford was an ex-mayoral candidate. So two outstanding people, and they decided to make a newspaper called the Saturday Press. And in their first article they published, it was an article essentially saying Jewish gangs were overrunning the city, and they specifically cited three candidates in the government that were not doing anything about it. So it was pretty scandalous, and it was pretty defamatory too. People weren't sure if this was correct or not, and they weren't really sure how to interpret this information. So obviously the article was super unpopular with the people. They really didn't like it, already because these two people were just unpopular individuals. It was considered racist, hateful, and scandalous, and Guilford, almost immediately after it was published, got shot. So that's kind of why it's called Neer versus Minnesota. So they took it to court. And the people of Minnesota decided to file this under the Public Nuisance Law of 1925, also called the Minnesota Gag Rule. And essentially that was put in place so that people would, newspapers wouldn't be considered scandalous, and then kind of shut newspapers down, almost an excuse. So in the first ruling, the courts decided, you know what, this was wrong, we don't like this paper, we don't like anything it said, so, you know, Neer, stop the paper, you can't write it anymore, we're not huge fans. But they decided this case was pretty important, dealt with a lot of issues, so they decided to take it to the Supreme Court. So once it got to the Supreme Court, the court looked at it, and the first ruling was, you know what, this article could potentially endanger lives. They said something along the lines of, it could like incite a riot, but the people were really upset about it. So they decided, you know what, Neer, we agree with the lower courts, we think you're wrong, we think you should take this paper off the press, you're done. Neer was not having that as an answer though, so he decided to go for round two. This time he decided to call that the Minnesota Gag Rule was unconstitutional. He said it was limiting his freedom of press and speech, and so he took it right back to court again, and he was trying to cite the Bill of Rights on this one. So he was again asking, is this unconstitutional? Kind of, these are my rights as a person. I mean, what I may say may be considered racist, but where can you get out, like, where's the line drawn between what I can say and what you guys can suppress me saying? So he took that to the Supreme Court for a second time, they took a second look at it, and they decided that, you know what, Neer actually does have the freedom to speak this way. And in doing so, they cited the 14th Amendment, so they said, again, he does have a right to say this. Under the states, it is true, and we can't suppress it, unfortunately. A lot of people were very upset with this outturn. In doing so, they added one brief legal loophole, though, that said anything with a draft or with war, if you write scandalously or endanger American lives, we can censor that, and we will censor that if we feel the need to. And so that was one important loophole, but other than that, completely free speech. So it basically became finalized. Neer and Guilford were declared not guilty. The Minnesota Gag Rule was found completely unconstitutional. However, being two very unpopular men, Guilford was shot again. This time they got him, so he did die. So they had a bad streak of luck, essentially. When looking at this case, one of the most important case influences was Schenectady v. the United States, so that was the one saying you can't yell fire in a crowded movie theater. And this was important again because they were looking at free speech, and it established that if a press or speaker, you know, clearly creates a danger, a clear and present danger, you know, he's in violation of the first rule, and they found that Neer did not do such a thing. So that was part of the reason. This is a very landmark case, obviously, very big in terms of freedom of the press and freedom of speech, a lot of impact. It's still examined today. And it's certain that basically no matter what, the Constitution is there to protect your most basic rights. In today's world, I think we can find this super applicable, especially now with WikiLeaks. You have Julian Assange, Edward Snowden, and kind of all the information they're sharing right now. And it's kind of a big dilemma because you have to ask yourself what's okay to share and what's not okay to share. Recently, they've been sharing a lot of military and governmental secrets, and so a lot of people are currently in debate about, you know, why can they do this? Can they do this? And so people have been citing the First Amendment and the 14th Amendment a lot. And people are still kind of in contention about whether this is right, whether this is wrong. But I mean, you have to ask yourself, when is this occasion to share? So right now people are debating, should we consider them heroes or traitors? Because on one hand, you know, they're sharing a lot of good information with the people, stuff that we didn't know before. On the other hand, though, they could potentially be endangering us because this is information that was clearly kept for us for a reason. So kind of what lies ahead? Regarding the First and 14th Amendment, technology is becoming more and more expansive, and information sharing is just getting easier and easier. So I think it's pretty normal to expect the First and 14th Amendment to be continually cited just because so much is happening. So I think this case is going to be examined for a long time more. And with the growing increase in technology, I think it's reasonable to believe that they're going to have to re-examine how they look at what constitutes a violation of the First and 14th Amendment. But I think in the long run, it all comes down to life, liberty, and the pursuit of happiness, and whether or not those basic rights are being ensured for the people. So, that is my presentation. Oh, I thought I had it. Sorry. That's a long 15 seconds. Unless it just keeps on going.
You might have messed out of time for me right now.
I don't think I did.
Yay!